My guest at this time is Roger Gannam. He's the Assistant Vice President of Legal Affairs at Liberty Counsel. We want to get his thoughts on how the Supreme Court is handling some hot-button cultural issues as it nears the end of its term. And Roger, thanks so much for being with us.
Thanks for having me. Glad to be here.
Let's start with abortion. There's so many different dimensions to this. At issue was laws out of Indiana, and the Supreme Court giving a split decision here. It did uphold the law that required the burial or cremation of fetal remains, which is a major pro-life victory. But at the same time, though, it let a lower appellate court ruling stand, which does not enforce the ban on sex-selective abortions, race, and disability. And so that is a loss for the pro-life side. At the same time, you've got Justice Clarence Thomas saying that the scope of abortion does need to be dealt with because otherwise you're starting to get into eugenics. In fact, he thinks we're already there. So let's take them one at a time. What do you make of the court upholding the disposal of fetal remains in a way that is consistent with how the remains of any person has to be disposed of?
This really is a good result from the mixed bag decision because what it does is it presents an argument legally that aborted babies are in fact human. And in each law that is passed that recognizes the humanity of unborn babies is a step towards regaining or reclaiming a pro-life culture. So it really is a big deal. Even though this is something that happens after an abortion, it's an acknowledgement by the court that unborn babies are humans, and that's a good result.
And then when it comes to the other part of the law, one that Mike Pence, now the vice president, of course, was governor and was championing, was one that dealt with banning abortions because it's not the sex you wanted, it's not the race you wanted, and you might get a prenatal diagnosis of a disability, whether it's Down syndrome or something else. Ultimately, that passed and became law in Indiana, but was struck down by the courts, and the Supreme Court did not side with the state on that. What's your reaction to that?
There's two ways to look at this. One, it is disappointing that the court would not take this up and uphold the law that, whatever you think of abortion and how morally wrong it is, there's an even greater moral culpability to have an abortion because you don't like the sex of the baby or you don't like the fact that it's been diagnosed with Down syndrome or some other disability. So sex-selective abortion is really it's an idea that is morally abhorrent, even more than abortion itself. But that said, we did get a concurring opinion from Justice Clarence Thomas, who spoke very clearly about the founding and the inception of Planned Parenthood and its association with the eugenics movement, the idea that we should eliminate unwanted members of society to make society somehow healthier, and showing the connection between birth control and the eugenics movement and then abortion in the eugenics movement. Clarence Thomas made a very good moral and legal argument that I think shows us how he will rule when the right abortion case is taken up by the court. And with so many working through the system right now, I think that day is coming very soon when the right case for perhaps a 5-4 majority of the Supreme Court will do something to Roe v. Wade, if not overturn it completely, severely restrict its reach.
Roger, it's been said that obviously with the ascension of Justice Kavanaugh to replace Justice Kennedy, that the court now leans probably more to the right. But there's been a couple of cases now where the pro-life side has been a little bit surprised by what Kavanaugh has done. When it comes to the Chief Justice, he's seen more as an incrementalist. And so some folks were perhaps they love the Alabama law on the pro-life side, but they're not sure it's the right case to bring to the court because they think maybe a 20-week pain-capable ban would be something that Justice Roberts and maybe Justice Kavanaugh would be more likely to get behind rather than one that bans it completely and sends it back to the states. What's your read on that?
Well, that's a really good point, and it reveals the mystery of the thinking of Supreme Court justices. We really don't know how these justices are going to rule, and I think you saw strategically the 20-week abortion bans weren't challenged with the same vigor as some of these other abortion laws because the pro-abortion side was really worried that a ruling by the Supreme Court would uphold that ban and accomplish that incremental move towards eliminating Roe v. Wade. But I do think that at this point it's going to happen. So many states now, there's so much momentum towards states, in a sense, outdoing each other by passing laws that are more restrictive of abortion, in the same way that states like New York are trying to outdo one another in passing laws that are permissive when it comes to abortion. So the die has been cast, and we're going to see some of these laws end up in the Supreme Court. And what I think you're seeing on the side of Justice Thomas in issuing his concurring opinion yesterday is the conservative justices are showing some restraint. They're not just going to take the first case that comes before them, but they're going to wait for the right one that I think that they think will do the most good for the constitutional principle of life. And Justice Thomas made it clear, abortion is not in the Constitution. And we have to keep in mind that the majority we're looking for is not a majority that's simply pro-life, but a majority that recognizes the constitutional protection for life that is built into our Constitution very clearly, and they want to issue a ruling that's consistent with the Constitution.
The concern, for example, if the Alabama law were to be the one that comes before the Supreme Court, is that a defeat, whether it's Roberts or Kavanaugh or anybody else, sides with the 4 liberal justices, that could be a huge legal setback because it sets another precedent, along with Roe and Planned Parenthood versus Casey, that would be harder for pro-life forces to come up with. So do you think the real telltale sign is whether or not the court accepts the case, and if the conservatives on the court don't think they've got 5 votes, they're probably not going to hear it at all?
I think that's a really good point as well. I do think it's the case that if the conservatives don't think there will be a 5-4 majority, they're more likely just to leave the case alone. Sometimes, however, their hand is forced when we get what's called a circuit split, where if the law in Alabama, for example, goes to the 11th Circuit and a law in another state goes to a different federal circuit, if those circuits issue conflicting opinions, sometimes the Supreme Court doesn't really have a choice but to take up that case and break the tie. So we could see that as well, because the abortion laws being challenged are coming from all over the United States. So I do think it's a fair assumption that the conservative justices won't take up the case if they don't think they can accomplish a majority decision. But at the same time, their hand may be forced by so many of these cases being challenged around the country.
Roger, major issues, and we're about to hit June, so the court's going to be real busy with some other major decisions. Thanks very much for your time today. We appreciate it.
Thank you for having me. Enjoyed it.
Roger Gannam, Assistant Vice President of Legal Affairs at Liberty Counsel. I'm Greg Columbus reporting for Radio America.